Michael Popok, Legal AF, a federal judge in Arkansas, has put a stop for now to the attempt to criminalize and put librarians and booksellers in jail for making available on the stacks and racks of their libraries and bookstores materials that could be harmful or obscene to any minor from 0 to 17 without regard to age, without regard to the concept that on a sliding scale, a book or a material that would be obscene to, let's say, a 5-year-old is not obscene to a 14-year-old or a 17-year-old, right? Catcher in the Rye and the masturbation scenes that are depicted in there, I'm not sure I'd want my 5-year-old to be reading. But my 14-year-old or my 15-year-old, I would be shocked if he didn't read it or she didn't read it. Same thing with a famous work of art like Ulysses by James Joyce. Plenty of sex scenes in there. Not sure they're right for 4-year-olds, but I think they're proper for freshmen in high school. Not in Arkansas. And in the new bill that was supported by Sarah Huckabee, the governor, and by its attorney general in that particular state, they think Act 372, a new law that would have went into effect in August, is just fine. Notwithstanding the fact that an almost identical law trying to take books off of shelves and to restrain and restrict and interfere with the First Amendment rights of Americans to both speak freely and receive speech at the same time was struck down by the Arkansas Supreme Court just 20 years ago. But just like every other MAGA red state in America, they've decided to try to out-woke the woke mob that they're so worried about, the critical race theory mob that's, in their view, making their children into degenerates. And the solution for that is to deny children between the ages of, let's say, 5 and 17 basic knowledge and take it off the shelves. And for good measure, put librarians and booksellers in jail. Now, the judge in this case, Timothy Brooks, in the Western District of Arkansas, is an Obama appointee. And so he spent a considerable amount of time in the order in granting the injunction to stop the enforcement of at least 2 major aspects, basically gutting Sarah Huckabee's anti-First Amendment Fahrenheit 451 law. And in doing so, he actually led off in his 49-page opinion with a quote from Ray Bradbury, the author of one of the most famous books on book censorship around, a science fiction piece, but it's becoming science fact, called Fahrenheit 451. Go read the book, go watch one of the movies that was made about it, in which firemen in that society in the future are required to find, locate, and burn books. And the only way books survive in that culture is that individuals memorize entire books from the beginning to the end, and they become that book so they can pass that knowledge on in the future. And the judge thought so much of that book and what this law says that he actually led off his decision with a quote from it. And the quote he leads off with, and I'm going to read it to you now, is from Ray Bradbury. It's not from the book, but it's from an interview that he gave, in which he said, "There is more than one way to burn a book, and the world is full of people running about with lit matches." And to this judge, Judge Brooks, Sarah Huckabee's law, supported in the Senate, is an attempt to burn books right before our very eyes, because it would have required that anything that someone deemed to be obscene under a definition, which would include sex acts that have no artistic, medical, legal, or scientific merit to them, that's in the eye of the beholder, they would have to be segregated and removed from places where a minor, now remember, minors are toddler, I'm talking about people that go to libraries, toddler to 17 and 364 days, okay? A toddler could have his mind blown by something that would be seen to be obscene that a 17 and 4/5-year-old would not find to be obscene. But this law makes no distinction between it. So now you're turning the librarians, Arkansas law, into the Gestapo, who are going to have to, because how are you going to put them under lock and key? I mean, literally, you're going to do it like, razor blades and other things at the CVS that you have to call over the assistant and blow a whistle because people keep ripping it off. You have to put these books under lock and key, because what's to stop a 13-year-old from wandering into a section? And how does anyone know? And this is the vagueness, constitutional vagueness and overbreadth of the law. How does anyone know what is obscene to a 14-year-old versus a 6-year-old versus a 17-year-old? That's why this is impossible to enforce, therefore a violation of First Amendment and 14th Amendment equal protection rights. That's what the judge concluded. But this is the firewall the federal judges have to put up against the worst instincts of populism. I mean, if you're going to go back to de Tocqueville, who toured America in the 1830s and wrote Democracy in America, he said, and it stands today, that the tyranny of the majority is only stopped by the barrier, right? That populism is only stopped by the barrier of lawyers and judges, right? Otherwise, you would just have it run completely amok in a pure democracy. And whatever was a heated issue at the moment, regardless of your constitution, would become your policy. And thank God Judge Brooks said, we're not doing that. We're not criminalizing and putting into jail under criminal misdemeanors librarians, because this law would have also stripped from them the immunity that they always enjoyed in Arkansas of not being accused of peddling obscenity if somebody checked out a book from the library stacks. Because the judge also commented, because he made it, and replete throughout his decision are references to history, theologians, statesmen talking about the purpose and role of a library in a community. And Carnegie, he said that a library is an unending well in the middle of a desert. And if you could only do one thing for your community leaders, it would be to establish a library. A library is so important to the American culture and American founding fathers that Benjamin Franklin is credited with founding the first public library. And Thomas Jefferson, after the British burned General Washington's and the President Washington's book collection, sold his book collection in order to raise money to establish the Library of Congress. So I'm sorry, Governor Huckabee and your Attorney General, we're a little touchy about public libraries, their role in society, that they're not a offshoot of the state government. And get your grubby hands off the First Amendment rights. As the judge says, every American, once born until they die, enjoy First Amendment rights under the Constitution. Now, if you're minors, there are some limitations around that. But for adults, freedom of speech means freedom to speak and to receive speech, including in the form of books and in writing. And so Act 372 of Arkansas law that was going to go into effect August 1st, at least to its two major provisions. Section 3, which would have criminalized librarians and booksellers who had a role in allowing some sort of minor between the age of 0 + 1 and 17 and 364 days, that's out. We're not going to criminalize them checking out books. And Section 5 set up this elaborate but ridiculous grievance process for a citizen. And there's going to be one in Arkansas somewhere who's going to complain about some book. What's Ulysses doing there? What's Catcher on the Rye? What's the Judy Blume books doing? Why are they up on the shelf? Maybe there's something dirty in Encyclopedia Brown. I don't know. I haven't looked at it recently. And they challenge it, so they have to go to the librarian and fill out a grievance report. The librarian has to conduct a hearing in which they consider the book. And if the guy or the woman or whoever doesn't like The result, the book stays on the shelf. Then they can go to their city council or town government or whoever pays the money for the public taxpayer-funded library and go have a hearing there. This is Ray Bradbury's "The world is filled with people with lit matches, and there are many ways to burn a book." Well put, Judge Brooks. We will follow what happens next out of the Western District of Arkansas, as the state of Arkansas and all of its local prosecutors no doubt appeal to the next level of appellate process in Arkansas and perhaps ultimately to the U.S. Supreme Court, who's going to have to take a position about First Amendment public libraries and the right of people to be freely educated. I'm going to follow it on Hot Takes, just like this one. I only do it in one place, because that's where I sit at the intersection of U.S. law and politics. It's called Legal AF and the MeidasTouch Network. And you can follow my work only there. Go over to YouTube, free subscribe to the MeidasTouch Network. You can go onto one of my playlists. You'll get all 300 of my hot takes that I do about every day on all sorts of topics in politically charged litigation matters. Follow me, Michael Popok, on all things social media at MS Popok. This is Michael Popok, Legal AF reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.